Ma'am, are you there? Ma'am, please unmute your mic, ma'am. Okay.
Hello, everyone.
Hi, ma'am. Good afternoon.
Madungog na ko, ma'am. Loud and clear. Okay. I'm super excited today for I am tasked to introduce our crowning guest. Joining us today is the living idiom of a man who happened to be born in the right time and at the right place in the year 1980. Coupled with an impressive background, he graduated his college at Xavier University, Ateneo de Cagayan, with a degree of Bachelor in Science in Business Management in the year 2002. In 2009, he graduated in the same school of his Bachelor of Laws. With his perseverance, good interest, and hard work, he passed the bar examination in the following year, 2010. He served as a lawyer in the following offices. 1. Palasan Galion Apolinario and Del Puerto Law Office. 2. Dumlao de Lima and Del Puerto Law Office. 3. Del Puerto Law Office from 2012 to 2017. Because of his authentic love of service, and he has a heart to serve our very own Department of Education. In the year 2018 until at present, in the division of Cagayan de Oro City, serving as Attorney 3. Friends, ladies and gentlemen, to the topic, finding, investigation, and sample case. This afternoon, Attorney Lawrence Edgardo Araula del Puerto.
Hello. Hello.
Hello,
Hi,
sir.
sir. Hello.
Hi,
Hi,
sir. Good
Hello.
afternoon.
Hello, sir.
We were hoping that
Okay. Thank you for that introduction. Can everyone hear me? Okay.
Yes, sir.
Yes, sir.
first of the things that we thought
I
is
am tasked to give a lecture for mediation, conflict management, and about fact-finding investigation. Now, we only have around 3 hours, and we even have to start late because we have to wait for the participants. I'm not really sure whether I can finish everything in 3 hours. So I'll try to give a shortened discussions about these things so that we can also have some time to be able to raise questions or clarifications in any of my lectures. So to begin with, I would like to start with the mediation process. And let me see if I'll share my screen. Okay, so once again, good afternoon, everyone. Thank you for inviting me to be your speaker. I am deeply honored to be able to help you with understanding the alternative dispute resolution in the Department of Education. Our slides here we would like to give thanks to Attorney Aris Delson Cawilan. He was our lecturer during uh, national training for legal officers in Cebu. So we will be using his slides, and we will be using his presentation with regard to alternative dispute resolution. So, well, we have here that our intention for this session is that you will be able to understand the basic concepts of conflicts, and of course, the alternative dispute resolution, or ADR for short. And then we will discuss the modes of settling disputes, understand the importance and benefits of alternative dispute resolution, and provide guidance in handling grievance complaints in DepEd, and of course, discuss the basics of mediation in the Department of Education. So, what is conflict? Of course, everyone knows that conflict is being defined as a strong disagreement between people or between parties or groups. It is usually result in angry argument or a difference that prevents agreement. So the disagreement can be between ideas, feelings, etc. So what are the benefits of alternative dispute resolution? The alternative dispute resolution is less structured, less expensive, non-adversarial or less adversarial, and you don't need the services of a lawyer. That's why it's less expensive, because you don't need to pay for a lawyer. No, you don't need to use a lawyer in alternative dispute resolution, and it is more speedy, and the parties may settle their disputes on their own. Now, unlike litigation, it is very structured, expensive, adversarial, and it needs a lawyer, and it needs more time to resolve. So, in the Department of Education, if we talk of litigation, the DepEd order that governs it is our DepEd order number 49, series of 2006, otherwise known as the revised rules in administrative cases in DepEd. Whereas for the alternative dispute resolution, we can see this in grievance proceedings as stated under Department Order number 35, series of 2004, and mediation proceedings, which is also under Department Order number 15, series of 2012. Now, just to see if you can hear me, and I think the I think grievance proceedings has already been discussed to you. Am I correct? Hello? Where is it?
Yes, sir.
Okay. I'm So wait a minute, something my laptop is very slow in uploading. All right, there you go. Oh, no, this is different. Okay. So I won't touch more details on grievance proceedings. That will deal with alternative dispute resolution. We will just touch grievance proceedings in relation to alternative dispute resolutions. So in the grievance procedure, there are two things that can happen. Can be a combination of mediation and arbitration. So what is the difference between mediation and arbitration? In mediation, the parties are first encouraged to settle their issues together to arrive at a mutual solution. So that is mediation. When you let the parties agree among themselves to arrive at a mutual acceptable solution or a settlement, no, an amicable settlement that both of them will agree. That is mediation. But if the grievance handler decides to resolve the issue, so if the handler is the one that will provide the solution, that is arbitration. Where if it is the parties that provide the solution and both parties accept the solution, that is mediation. So that is the difference between mediation and arbitration. So, of course, we already know about the grievance machinery. So, this is among the employees of the Department of Education, regardless of their appointment. And so, there is no need for me to discuss much about the grievance machinery, right? Because this has already been discussed, right? Am I correct, people? Hello?
Sir, yes, sir.
Okay.
Yes.
So just a little review, there are cases wherein that are not covered by the grievance machinery, and usually these are disciplinary cases or cases that are resolved pursuant to DepEd Order number 49 series of 2006, otherwise known as the Revised Rules of Procedures on Administrative Disciplinary Cases. And of course, sexual harassment cases that's not subject to uh, please, let's have a little break, just 1 minute. Hello. Sorry about that one. Okay, and then we also have union-related issues and concerns and child abuse cases. So remember, this is very important, especially in child abuse cases. You do not try to mediate or offer a settlement or try to have an amicable settlement between the parties if the situation is sexual harassment, union-related issues and concerns, and child abuse cases. So if it is an administrative case, of course, no, you follow the O49 series of 2006. So just to give a difference between the administrative proceedings and the grievance proceedings, in grievance proceedings, the one that has jurisdiction is the immediate supervisor. But in administrative proceedings, if the if the respondent is a teaching personnel or a teaching related personnel or a regional office personnel, it is the regional office or the regional director, no, who has a jurisdiction over the administrative case. And if the respondent is a non-teaching personnel or a division office personnel, then it is the school division office. No, it is the superintendent office of the superintendent division office or the office of the school superintendent that has the jurisdiction. Whereas in grievance proceedings, it is the immediate supervisor or the grievance committees. So what are the processes involved? In administrative cases, of course, disciplinary proceedings, as mentioned under DO 49 series 2006. Whereas in grievance proceedings, you apply mediation and conciliation proceedings. So mediation is very applicable only in grievance machinery. No, so the moment you apply grievance machinery, you should be able to know how to handle mediation. So we already know the different committees under the grievance procedure. So I think that this has already been discussed, so I will not anymore discuss this one. I'll just discuss on how the grievance in relation to mediation should be handled. So the following should be observed. The employee or the aggrieved party shall be put at ease. Every effort shall be exerted to make the employee who has a grievance feel at ease during oral discussion. So always remember, no, to make the employees or the aggrieved party feel at home or feel comfortable, so that he can freely open up anything that is hurting the aggrieved party, no, so that she will be open up all her grievances, his or her grievances, to whoever that he has a problem with in the working relationship at work. So if you are the immediate supervisor or the grievance committee, you make sure that the aggrieved party will freely open up his feelings, and he can freely discuss the grievances that you have. And then the employee or aggrieved party shall be encouraged to talk. The employee shall be allowed to tell or explain his or her side during the oral discussion. So always try to encourage the aggrieved party to open up, no, to open up everything. Do not hide everything. There is no bad consequences by telling everything that you think that you have agreed that the aggrieved party has a problem with. No, so make sure that the aggrieved party will open up and talk and express his or her grievances. Privacy in discussion. The oral discussion shall be held in a private and a quiet and secluded spot where the conversation cannot be interrupted or overheard. So make sure that you undertake the grievance procedure. When you have a grievance procedure, it must be in a place where you cannot be interrupted or overheard. And then the case shall be heard fully. So the supervisor or the committee shall seek to keep his or her views and opinions entirely to himself or herself until after the employee has explained his or her side during the oral discussion. So you as the handling supervisor or the grievance committee, if you are the one handling the grievance problem, you really have to make sure that the employee has be able to fully explain his or her side during the oral discussion. So you can even ask the aggrieved party, is this everything that you would like to say, or do you would like to add more? So feel free to open up. So you tell the aggrieved party. And once the aggrieved party has opened up, you can reaffirm or ask a confirmation that is this everything now that you would like to to share, and there is nothing more. So anyway, she said, I have shared everything that I need to share and express all the grievances that I have expressed, then that's it. You are able to heard fully his side. So a definite decision shall be reached. At the end of the discussion, the supervisor must be prepared to state his or her position clearly and accurately based on the merits of the grievance. He or she need not immediately give a definite decision, but the decision shall be rendered within 3 days from the presentation of the grievance. So after the party had expressed all his or her grievances, you if you are the supervisor or the grievance committee that is handling the grievance procedure, you need not tell directly what is your position on the problem, no, on the merits of the grievance. You can wait for 3 days to be able to present your position. But you can also, if you want, if you already know what is your position on the problem, then you can already state clearly and accurately, no, what is your position right there and then. But if you are not yet ready to give a position clearly and accurately, then you cannot wait for at least 3 days. Now, if the aggrieved party is not satisfied with the verbal decision, he or she may submit the grievance in writing within 5 days to the next higher supervisor, who shall render his or her decision within 5 working days from receipt of the grievance. So, as in a case, if the aggrieved party is not satisfied with the decision of the handling supervisor or the grievance committee, then he may appeal. So, okay, so I think we already know the procedure for appeals. In any case, if there are matters that matter of technicalities as to the way the grievance committee should be handled, you may check the appropriate department order regarding that deals with the grievance procedure, and you can check there. And if you want a copy of this, I'll uh, I'll send a copy to Louis Ruferos, so that if ever you also need to re-echo this or give to a seminar or for your own consumption, if you were not able to fully grasp the grievance procedure and everything, you can use this presentation. So I'll give a copy of this one to Louis Ruferos, and there you can review the things that I have said and the things that are written here. So we shall continue now with mediation. Now, mediation, as described under Department Order number 15, is under Department Order number 15, series of 2012. So, if you want to check, just check Department Order number 15, series of 2012. Now, mediation is a structured process and mechanism of alternative dispute resolution where party autonomy is afforded to disputants. The decision rests on the parties, they being the decision maker. So remember this, as a mediator, you are not the one that will decide for the parties. If you are a mediator, you must make a way wherein the parties will arrive at a decision. So wherein the parties will be able to provide the solution of the problem. So as a mediator, you are only a mere facilitator. Okay? Now, mediation is bound by confidentiality rules. So, and also councils cannot take part in the mediation session. They only act as mere observer. So, take note, lawyers should not have an active role during mediation. They are only there to observe. And the proper subjects of alternative dispute resolution mediation in the Department of Education include light offenses, which has the corresponding penalty of reprimand. This is provided under Section 58 of Department Order number 49, Series 2006. So if you want to know what are the offenses that can be subject to mediation, you just look into Section 58 of Department Order number 49, Series 2006. There is a long list of light offenses that are enumerated there. So you can check that one so that you will know what offenses wherein you can conduct mediation, because not all offenses that under administrative cases are subject to mediation. As I've cited before, sexual harassment cases and child abuse cases, they cannot be subject of mediation. And of course, grave offenses, because only light offenses are subject to mediation. Above, if it is not a light offense, then it is not subject to mediation. So a mediation unit must be composed of 3 members who are non-mediators, with 1 member preferably coming from the legal office. So if you have a legal officer, then he is preferred to be also a member of the mediation unit. And then the one that will manage disputes must be at their respective levels, which include monitoring and evaluation of the implementation of the mediation program and the performance of the mediators. And as much as possible, you should be able to maintain a roster of trained mediators. So it is best advised that there should be a different training, because there is really a different training for how to mediate for mediators. So what are the qualifications of a mediator? Number one, he must be willing to assist the disputing parties. He must display patience, empathy, and integrity. Has completed 40 hours of classroom training on mediation and the corresponding 40 hours of internship. Certified by recognized mediation training institution and by DepEd as a mediator. So number one, you must have a certificate. You must remember that there's a certain 40 hours of classroom training on mediation and a corresponding 40 hours of internship, and this must be certified by a recognized mediation training institution and also by the DepEd as a mediator. So this will qualify you as a mediator. So what are the subjects of mediation? The grievances, light offenses under DepEd Order number 49, Section 2006. And of course, if there is a request for assistance and mediation is available or viable. So these are samples of light offenses that are subject to mediation. No, we have discourtesy in the course of official duties, violation of reasonable office rules and regulations, frequent unauthorized tardiness, gambling prohibited by law, refusal to render overtime service, borrowing money, disgraceful immoral dishonest conduct, willful failure to pay just debts, lobbying for personal or interest or gain, and failure to act promptly on letters and requests within 15 days from receipt, except as otherwise provided in the rules implementing the Code of Conduct and Ethical Standards for Public Officials and Employees, failure to process documents and complete action on papers within a reasonable period of time. All of these things, no, these are written in the Department Order 49. And then, what are offenses that cannot be subject of mediation? So once again, for your review, sexual harassment cases, child abuse cases, cases involving against violence against women and children, disciplinary cases not provided under paragraph 1, section 4, issues and problems related to the performance and evaluation system, motu proprio cases, and anonymous complaints. So what is the objective of mediation? Well, number one, it provides a fast, fair, and non-adversarial process, and it can manage disputes at the lowest possible level mediation units. It can enhance the existing mechanism in managing disputes and develop the capabilities of personnel in managing disputes at all levels. So this is the mediation process in the Department of Education. The complainant submits his complaint to the head of office, and then head of office will set up a mediation unit, and then the mediation unit will handle the complainant and the disputant. If it is the mediator was able to resolve the problem and there was the problem was resolved by an agreement, then that's it. But if it is not resolved, then it will be referred back to the proper disciplining authority. So processing and filing with the head of office, that's the first process in mediation of the if you have if the aggrieved party has a complaint, you must first file with the head of office. Then the head of office will refer to a mediation unit. Then of course the mediation unit makes initial evaluation, and the mediation unit recommends for mediation. Then the docketing of the case for mediation, and then the proper selection of the mediator. Then the mediator conducts initial conference. The parties sign the agreement to mediate. So the mediator must make sure that the parties will sign that they agree to a mediation. Then the mediation session will now begin. Now, as it commences, there will also be a termination of the mediation, and then the signing of the of the settlement agreement. So, if ever the parties was able to reach a settlement, make sure that there will be a written settlement agreement and the parties will sign it. And then this will be deposited and the settlement agreement will then be enforced. So that is all for mediation. I hope you're able to learn something, even though we fast track a lot of topics and issues, because some other topics I understand were already discussed to you, like the grievance procedure. So before I'll have a water break for a minute. Do you have any more questions? Do you have any questions? Hello? Hello? Can everyone still hear me? Anyone can hear me?
Yes, sir.
Yes,
Sir,
attorney,
loud and clear.
listening.
Okay. So, do you have any questions with mediation? Hello? None? We will proceed
None,
with fact finding.
none, sir.
None? Okay. So, once again, I'll proceed to fact finding investigation. Okay. Before I'll proceed with fact finding investigation, remember that before you will be able to conduct a fact finding investigation, there should be a sworn and a sworn affidavit complaint. No, make sure that the affidavit complaint must be sworn to. And if ever you receive an order to conduct a fact-finding investigation, and as a fact-finding investigation committee, you found out that the complaint is not a sworn affidavit complaint, but it's just an ordinary letter complaint, then you should order the complainant to submit a sworn affidavit complaint, and also to submit a certification of non-forum shopping. So before you proceed with your fact-finding investigation report, make sure that or your fact-finding investigation, make sure that the complaint is a sworn affidavit complaint. Now, as stated in our DO 49 series of 2006, the fact-finding investigation, uh, please bear with me for a little while. I'll show a little. I'll share first the DO 49 series of 2006 before we will proceed. Please bear with me for a little while. I'm still downloading a copy of DO 49 before I'll proceed with my discussion with the fact-finding investigation report. Okay. Okay. So, all right, here it is. Okay. Okay, guys. This is DO 49 series of 2006. Now, under Section 8 of DO 49 series of 2006, under letter A, I would like to emphasize this because sometimes this one seems to have been forgotten or has not been being followed by or just been taken for granted by the disciplining authority. Now, let's review again that remember for teaching personnel, the disciplining authority is the regional director or the office of the regional office. While the disciplining authority for the non-teaching personnel under the jurisdiction of the division office or school division or the division office personnel, non-teaching, the disciplining authority is the office of the school superintendent. Now, here in letter A of section 8, it says here that the disciplining authority concerned shall dismiss outright a complaint if on its face there is obviously no truth or merit to the allegations therein. So if you have if you will be the one tasked by your disciplining authority to evaluate whether the allegations of the complaint should be given due process or whether it should be uh, subjected to a fact-finding investigation, make sure first whether there is merit to the allegations or as it stated there is if there is obviously no truth, no, or merit, there is no obviously no truth or merit. So if there is no truth or no merit to allegations therein, then you can dismiss outright a complaint on its face. So that doesn't mean that all complaints, this means that it doesn't mean that if someone complains, you should always subject it to a fact-finding investigation. In the first procedure, before a fact-finding investigation should happen, is that the disciplining authority should first determine whether there is truth or merit to the allegations of the complaint. Because here, I have seen a lot of complaints that are being subjected to a fact-finding investigation, even it is very obvious on the allegations of the complaint that obviously there is no truth to it or there is no merit to the allegations. So this letter A of Section 8, actions on the complaint, sometimes this is being taken for granted by the disciplining authority. So if you have time, if you have time, please remember this one. That it doesn't mean that if somebody will make a complaint against a teacher, a teaching personnel, or a non-teaching personnel, automatically the the complaint should be under subjected to fact-finding investigation. No, the first thing that the disciplining authority should do is to look into the truthfulness and or the merits of the allegations. If there is no truthfulness or merit to the allegations, then the disciplining authority can outright dismiss the case. So as we now let's proceed to letter B. The disciplining authority shall also dismiss if the same is not in accordance with the required form and or if it does not comply with the required content of a complaint. So, of course, we have certain requisites that the complaint must be subscribed and so on too. So, if it will not be in accordance with that one, then the disciplining authority can dismiss the complaint. No, but instead of dismissing the complaint, it is well advised that you give chance, or if the only problem is that the complaint is not properly subscribed and so on to, and there is no certification of forum shopping that had been submitted, what should be done is to give chance to the complainant to submit a complaint that is in accordance with the required form, and also the other requisites necessary like the certification of non-forum shopping. So if the complaint is sufficient in form and substance, the disciplining authority shall give due course to the complaint Okay. Now you see here, it is only, no, it's even on the letter C, it's on the third situation, it is only when the complaint is sufficient in form meaning it is subscribed and sworn to. And here it says substance. If the complaint is sufficient in form and substance. So here, in substance, it says here it must be sufficient in form and substance. So what does substance means? It means that the complaint must be, there must be some a little truthfulness, or there must be a little merit to the allegations in the complaint. If there is no iota or scintilla of truthfulness or merit to the allegations in the complaint, then the disciplining authority can outrightly dismiss the complaint. So it is only when the complaint is sufficient in form and substance that the disciplining authority shall give due course to the complaint by appointing within 10 days from receipt of the complaint an investigator who shall conduct fact-finding investigation or preliminary investigation. So that is the only time that the complaint will be given due course by the disciplining authority when the complaint is sufficient in form and in substance. That is the only time that the disciplining authority can give due course to the complaint, wherein he shall appoint a committee, fact-finding investigation committee, excuse me, to conduct the fact-finding investigation. And no action shall be taken on anonymous complaint unless the disciplining authority decides to adopt the same and file it motu proprio. So if it is an anonymous complaint, don't take any action. If it is an anonymous complaint,
Dita na po kasakuha nag-send. Malcolm na
unless
po.
there is an exemption, even if it is an anonymous complaint, but if
Unsent.
the disciplining authority decides to adopt it and will file a
Paano gan mo
prior
notify?
case, then,
Nawala lagi internet. Ano man eh.
hello? You cannot hear me anymore?
Why is that?
Sir, loud and clear.
Okay, because someone is speaking that there is no more internet. Okay, let me continue. So now we will talk of fact-finding investigation or preliminary investigation. So once again, fact-finding investigation should only be conducted when the complaint is compliant in form and in substance. So what are the procedure for the fact-finding investigation to happen? Within 5 days from receipt of the appointment of an officer of the Department of Education as investigator. So if ever you will receive an appointment that you will be a member or you will be the investigator of a fact-finding investigation issued by the disciplining authority concerned, the designated investigator shall commence the fact-finding investigation or preliminary investigation by issuing an order requiring the person complained of to submit within 3 days from receipt of the said order, together with a copy of the complaint and the supporting documents thereof, a counter affidavit or comment under oath, and the affidavits of the witnesses of the person complained of with supporting documents, if any. Failure of the person complained of to submit his counter affidavit shall be considered as a waiver thereof. So, the first thing you do, the moment that you receive an order that you will be the personnel tasked to conduct the fact-finding investigation, is you issue an order requiring the person complained of to submit within 3 days his counter affidavit or comment under oath, and then also the affidavit of his witnesses or any supporting documents if he have. Now, if ever the person complained of failed to submit his counter affidavit, then that shall be considered as his waiver. Now, upon receipt of the counter affidavit or comment under oath, the investigators may summon the parties to a conference where the investigators may propound clarificatory questions. The investigators may also interview any possible witnesses. So if you ask me, is a conference for the investigator propounding clarificatory questions necessary? My answer is it is not. It is not compulsory because the word used here is may. So it depends upon the fact-finding committee. If they think that it is necessary for them that they need to propound clarificatory questions, then they may summon the parties to a conference. But if they think that it is not anymore necessary, in my humble opinion, then there is no need to summon the parties because the word used by the DepEd order is the investigators may. So when you say may, it is not mandatory, no, for the investigator to summon the parties to a conference. That is only my humble opinion. But usually what we do here in our division, even though the word here used is may, we still we usually call the parties to a conference for clarificatory questions, no, just for compliance. Anyways, nothing wrong will happen. Nothing wrong is being done if you call the parties to a conference for clarificatory questions. But if ever you think that there is no need to call for a clarificatory questions, if you ask me, then using statutory construction, in understanding the wordings of DepEd Order 49, since the word used here is may summon the parties, then for me, that this summoning the parties to a conference is not mandatory. So anyway, in letter C, during any hearing conducted for clarificatory questions, the investigator shall maintain minutes of the proceedings which shall include the clarificatory questions propounded to the parties and their witnesses and the answers given thereto. Said minutes, which shall be signed by the parties and their counsels, if any, shall form part of the records of the case. After the termination of the hearings for clarificatory questions, the investigator shall make an ex parte examination of records and documents submitted by the complainant and by the person complained of, as well as the documents readily available from other government offices. Now here, honestly speaking, in my opinion, there is a word that I think was not appropriately used. This is ex parte examination. You see, when you use the word ex parte, even if I think if you Google it, it would mean that in the absence of one party. So if the meaning is in the absence of one party, it means that in the presence of one party, but in the absence of one party. But what you do here is that you examine the records and the documents submitted by the complainant and by the person complained of in the absence of both parties. So for me, this should be revised. The word ex parte should not be used because what we will be doing in the field is that we really don't examine the documents in the presence of one party and then at the absence of another party. What we do is we examine the documents in the absence of both parties. So this should be the investigator should make an examination of the records and documents submitted by the complainant. For me, there's a confusing part when they use the word ex parte examination of records, because in reality in practice we don't examine the records in the absence of one party, but rather we examine the records in the absence of both parties, the complainant and the person complained of. In any case, but it just the spirit of the spirit and intent of the department order here is that after you conduct the clarificatory questions, that's the time that you will be making the examination of the records and the documents submitted by the complainant and by the person complained of. Then, a fact-finding investigation or preliminary investigation shall commence not later than 5 days from receipt by the investigators of the order of the disciplining authority appointing him or them as investigators and shall be terminated within 30 days thereafter. So that's the time period for you to conduct your investigation. Now, the investigation report must be submitted within 5 days from the termination of the preliminary investigation or fact-finding investigation. The investigator shall submit the complete records of the case to the disciplining authority together with his or their investigation report, which should contain his or their findings and recommendations. And letter G, if a prima facie case established during the investigation, a formal charge shall be issued by the disciplining authority. A prima facie case shall mean that there is a reasonable ground to believe that the respondent is probably guilty of the charge against him and should be investigated accordingly. So when we say prima facie case, there should be a reasonable ground to believe that the respondent is probably guilty of the charge against him. So if there is no reasonable ground to believe, then there is no prima facie case. So now we will discuss how shall we make a fact-finding investigation report so that everyone is in in compliance with the format of the fact-finding investigation report when we have our training in uh, in Cebu for legal officers. They gave us a format for a fact-finding investigation report. So this is I'm showing to you through a PowerPoint a format of the fact-finding investigation report, and later on I will send a soft copy of a sample of a fact-finding investigation report, sample format, but I cannot send it now because the soft copy that I put in my USB was corrupted. So I'll be able to send it later, maybe after office hours, maybe around 5 or 6 p.m. Or maybe around 6 p.m. Once I'll be able to go back to my house, the source of my file is in my house. I'll send it to Louis Roferos, and if you want to have a sample of a fact-finding investigation report, you can get a copy from him. I'll also be able to share a file copy also of a of a script of a clarificatory conference, no, so that you can have a sample and you can picture out how to conduct a clarificatory conference in fact-finding investigation. So you are very lucky people because you will have already a chance to have a viewpoint, no, a sample of what is a clarificatory, how to conduct a clarificatory conference, no, wherein you propound clarificatory questions. I made the script just for you people, no, so that the moment you will be handling a fact-finding investigation report and you will call the parties to a clarificatory conference, you can already know how to handle and how to propound clarificatory questions during clarificatory conference meetings. So a copy of that and a copy of a sample of a fact-finding investigation report, I will be sending to Mr. Louis Roferos, and you can get a copy from there. And also, before I will end, because my report is nearing to an end, I would also would like you to look into the chat, because I shared in the chat my YouTube channel. I have a YouTube channel, and I am currently recording my lecture, and Louis is also currently recording this lecture. And later on, I'll be having the moment I have a copy of the recording of my lecture, I'll upload it to my YouTube channel, so that if there are matters that you would like to review, or there are other employees also of DepEd that would like to know about the mediation and fact-finding investigation, then you can share this video and you can be reminded of the lecture. So this is very important. I hope you will visit my YouTube channel, and there are also other videos there that are informative. You can also take a look and glance there about my other lectures about the laws in the Philippines, relevant laws in the Philippines that can help you, that can help enlighten you. So now let me go back to my lecture about fact-finding investigation report. So here is the format for a fact-finding investigation report. So basically, this is the general format. First is at letter A, you put on there on top. Of course, what the topmost, you have the header and the footer. No, you have your letterhead of your own division. After that, you write four. Four is if the disciplining authority, if the case is against, if the case is the person complained of is a teaching personnel, the one that you write for four is the regional director. But if the person complained of is a non-teaching personnel that is under the division, the four there is for the office of the school's division superintendent. So the four is the disciplining authority. True, and then the subject, and then the date. Title, the fact-finding investigation report, and then you have your introductory reference, factual antecedents, investigation events and content, findings, recommendations, date, name and signature of the committee's chairperson and members. So we will see a sample of this one. So for example, if the disciplining authority is the regional director, then your four is the regional director, and your true is the school's division superintendent. Then you will have your subject, and then you will have your date. But if the person complained of, remember, if the person complained of is a non-teaching personnel under the jurisdiction of the division, your four is the school's division superintendent. And then, of course, you put your title of your fact-finding investigation report. So what we usually do is just put here fact-finding investigation report on the complaint filed by example AAA against B for dishonesty. So a sample of introductory reference to the memorandum directing the investigation goes something like this, no? Example, on May 2, 27, the Division of Cagayan de Oro received a first endorsement dated May 16, 2016. Now, here you will be putting in footnotes, no? The footnotes, how it will be footnoted, you will be able to see the sample of footnotes in my sample format, no, of in my sample fact-finding investigation report. So this is just for a sample in the format, but it is more important for you to it can make you it can give you a clearer picture of what is a fact-finding investigation report if you will receive a soft copy of a sample of a fact-finding investigation report. So here we will just give a little run through, no, with what contents that you would usually find in the format of a fact-finding investigation report. And then the factual antecedents that led to the investigation, then you will write there that example, BB was a school teacher assigned at Macanhan. Yeah, she filed an administrative complaint by submitting a complaint affidavit dated blah blah blah. So you will write here what were the facts that happened which led to the investigation. Then the investigation events and content. So here you will write what happened during the investigation that you conducted. So usually you will write here what happened during the clarificatory conference. You will also write here. So here you can see that what happened, the events and the content. Like for example, in July 21, it was the committee issued an order directing Triple B to submit their counter affidavit 3 days. So that the timelines, the events, and your supporting documents are important. You will footnote this and put all your supporting documents in your investigation report. And then your findings. So here in your findings, this is where you will write what you found out during your examination, during your fact-finding investigation. So usually your findings are based on your examination of the documents, and also during the clarificatory conference about the clarificatory questions that you ask the parties. The things that you will find out there, you will write here on your findings, and this is where you will usually make a finding whether a prima facie case exists or not against the person complained of. So after the findings, you will now make the recommendation. So the recommendation usually is just like a conclusion of your findings. So if in your findings you found out that there is no prima facie case that exists against the person complained of, then you put here in your recommendation that the example, wherefore the foregoing premise considered, this fact-finding committee finds that there is no prima facie case against BBB for dishonesty. It is recommended that the complaint against BBB for dishonesty be dismissed. So you will make the recommendation accordingly. Then you will write the date and the name and signature of the committee chairperson and members. So here, you'll write here the Cagayan de Oro example, Oroqueta City, and the date, and then the names of the members and the chairperson. So that is it for the fact-finding investigation report. And I would like to thank you for listening to my brief lectures. And if you have, I intendedly wanted to end 15 minutes before 3 o'clock so that at least we can have some time for questions or clarifications that you would like to ask to me. So if you have any questions or clarifications, please feel free to ask. Hello?
Okay, so questions, Guleds?
Louis. Sir, good
Yes, sir,
afternoon.
Ray?
Little question, sir, to sir. In reference to sayang discussion, pwede ba kamutanan ka, sir?
Oh, yes, yes. Pangutana, pangutana.
Sir,
Kusga lang, kusga imong tingog. Kusga paliw.
nag-mention mo ka sa disciplining authority, sir, kung na-complain. Once it is received once it is received by the disciplining authority or the person concerns to create the investigative body, and yet the complaint filed is substantive and with merits, and yet the person concerned for that to make the investigation, wala siya magama, wala siya action. What could be the possible move of the complainant, sir?
So the disciplining authority wasn't able to take action on the complaint.
Yes, sir.
Is that your question? So what will be the legal remedy of the complainant?
Complainant.
Okay, my advice to that matter is if ever you know of a complainant and he already submitted his affidavit complaint, and that affidavit complaint is in whether in substance or not, whether it is in proper form and substance or not, the disciplining authority should take action. No?
Yes, sir.
If ever the disciplining authority will outright dismiss the case because it is not in form and in substance, that is still an action undertaken by the disciplining authority. No? So, but in your situation, you are asking that there is no action on the part of the disciplining authority.
Authority.
So, what on my part as a complainant, what step should I do? So, of course, you should the complainant, there should also be a little consideration of a reasonable time before you take action against the inaction of the disciplining authority, because we don't know if the complaint is still in the process or being endorsed. For example, if it is in the region and the disciplining is the regional office, and it takes time for the regional office to take action. But even after a reasonable period of time, let's just say I think 1 month is already reasonable, uh, there is no action on the part of the disciplining authority. What you can do as the complainant is, number one, you have remember, the complainant is supposed to have a received copy of his affidavit complaint. His affidavit complaint, there's a stamp
Stamp.
in the affidavit complaint, no, of the date
Yeah.
where when was his affidavit complaint received by the division office. So from that date, you attach that part of that part of your affidavit complaint where your affidavit was complaint received, and you write a letter to the disciplining authority. The complainant should write a letter to the disciplining authority following up on the status of his affidavit complaint that he filed.
Okay.
Okay. So with that letter written, it must be a written letter. It need not be subscribed to, just be an ordinary letter from a concerned citizen addressing it to the disciplining authority, and ask the disciplining authority what happened to the affidavit complaint that I filed. What is the status of my affidavit complaint? Because there is supposed to be a certain time period for the disciplining authority to take action with regard to the affidavit complaint that had been filed. Now, our citizens charter as the applicable time will cite the applicable time period for the our citizen charter even cites the applicable time period for the disciplining authority to take action. So with that, if ever for a certain reasonable period of time the disciplining authority was not able to take action, you advise the complainant to write a letter to the disciplining authority asking for the update or status of his affidavit complaint, so that he will know what action had been taken or if there is none. If there is no action taken, then if the disciplining authority is the regional office, then the complainant has the right to file a complaint or for neglect of duty on the part of the disciplining authority for na failing to take action on his affidavit complaint that he filed. So if it is the disciplining authority is the regional office or the division office or the school's division superintendent, then I think these two personnel of the Department of Education, the disciplining authority for these two personnel is the Secretary of Education. So you can advise the complainant, if you want, you can file a case for neglect of duty on the part of the disciplining authority to the Secretary of Education for their neglect of duty, uh, for their inaction, which is a violation of an administrative offense of neglect of duty under Department Order 49. So is that clear?
Thank you, sir. Thank you.
Okay, thank you. Thank you for that question. Any more questions?
Good afternoon, attorney.
Yes, may hapon.
Good afternoon. May hapon, sir. Nalang ko'y gamit sa conflict ba, attorney, between a parent and a teacher. Ang
Ah.
parent mo ay complainant, and the teacher is the person complained of.
Okay.
Then, unsa man na, attorney, can the parent go directly to the disciplining authority or ang school head sa mo ay mo settle first kung naay conflict?
It that one is with the prerogative with that one lies with the complainant.
Mm.
So if the complainant agrees that the principal will
Yes, attorney.
settle their differences, then the case need not be forwarded to the disciplining authority. But remember, the one that the principal can only
Yes.
settle are those light offenses. If the
Yes.
complaint of if the offense that is being complained by the complainant is not a light offense, then it should not cannot be subjected to a mediation proceedings by the principal or the school head. So, for example, if the offense that is being complained of by the parent is child abuse
Yes, attorney.
against his child who is the student of the teacher.
Yes.
If the offense is child abuse, the principal should not try to mediate.
Yes, attorney. Okay.
There are only if as a principal you can check on the light offenses. It is enumerated. Usually these are simple ones, like for example failure to pay just debts, like for example the teacher borrowed money from the parent, no, they are friends, and then they borrowed money and the teacher did not pay. So that one that can be subjected to mediation by the principal. But if ever the case is, it could be sexual abuse, sexual harassment, or child abuse, there are, like I said, there is a list of cases that cannot be subjected to mediation by the principal. So these cases should be filed with the disciplining authority directly, and no need to undergo mediation proceedings with the school head.
Sige, okay, attorney. Thank you. Thank you so
Okay.
much.
Thank you for the question. Any more? No more questions?
Attorney,
Yes.
nay lain po nga gihatag diri nga question. For example, attorney
Ah.
naay complaint dayon ang gisubmit nga documents kulangan.
Unsa daghan?
For example, attorney,
Unsay gisubmit nga
for
document?
example, among the required nga documents, ang kulang nga document nga wala na submit is katong certification for non-forum shopping.
Oh.
Can the disciplining authority dismiss the case outright for the lack of document na gisubmit sa required document?
The answer is yes, kung wala ang certification of non-forum shopping. Remember, the grounds for the dismissal, outright dismissal, is that when if the complaint is not in proper form and in substance, so certification of non-forum shopping is a requirement. But it is well advised that instead of outright dismissing the case, it is best advised that the disciplining authority should not outright dismiss the case for lack of certification of non-forum shopping, but rather the disciplining authority or the investigating committee in charge should write a letter to the complainant to comply first with the requirement of the DO 49. So instead of dismissing the case outright, it is rather preferred that that the committee or the disciplining authority or the fact-finding investigation committee shall write a letter first to the complainant telling the complainant to submit a certification of non-forum shopping or anything that he lacks, any document that he lacks uh, in order to comply with the provisions of the O49. This is the proper action to be taken instead of uh, outright dismissing the case. The proper action to be taken, although technically speaking, you can dismiss outright the case. But the problem if you dismiss outright the case, it is not on the merit. It is just on a mere technicality. So it's not more. It's better that the preferred course of action is to inform the complainant that he or she lacks a certification of non-forum shopping, or if ever the complaint is not subscribed and so on to, write the complainant first to comply with whatever missing requirements that the complainant has. So if he misses a certification of non-forum shopping, write a letter to the complainant to submit a certification of non-forum shopping. And if after a certain period of time, the complainant still refuses to submit a certification of non-forum shopping, then that's the time that you dismiss outright the case. So always remember to give a chance to the complainant to submit the proper documents. But after writing a letter to him, the complainant still fails to comply with the requirement, then that's the time that you dismiss the case. Okay?
Okay, attorney. So, pwede ra gyapon nga mo while waiting for the submission of the lacking document, can the investigation or fact-finding investigation can start?
No.
Dili
No,
gyud.
you're not supposed to start yet. What you should do, the fact-finding investigation report or the fact-finding investigation committee should write a letter or an order, no? You write an order directing either a letter or an order directing the complainant to submit the missing requirements. Failure to submit these missing requirements within a certain reasonable period of time would mean dismissal of the case.
Then, attorney, what would be the effect, attorney? Let's say na-dismiss ko siya because wala siya nakasubmit katong document nga kulang for a reasonable time, wala gyud siya nakasubmit. Unsay effect sa dismissal, attorney?
That's
If
what we call
mag-refile sila.
That's what we call a dismissal without prejudice of refiling. So the complainant can refile the complaint in this time together with if together already with the necessary requirements, then that complaint will still be given due course.
So without prejudice gyapon siya.
Oh, without prejudice to refiling because the dismissal is not on the merits. That's why although in the DO49 it says you can dismiss outright, we don't do that because it can still be refiled. So instead, what we do, we write a letter to the complainant to comply with whatever requirements that needs to be complied.
Okay. Thank you, attorney. Thank you.
Okay.
Anyone, do you have any questions?
Sir Louie,
Yes, sir.
additional question. Can we ask question beyond sa iyang concept, beyond sa iyang presentation?
Okay, I will answer if I have the information to knowledge to address it. Yes, I will answer that one.
Salamat, attorney, because it happens now in other division.
Hello.
Are complaining. Hello.
Louder,
magkano
please.
ba ko, attorney?
Hinay.
Klaro ba? Paano, attorney, in reference to the provision on nepotism,
Yes.
can you explain us further when this nepotism take effect on DepEd personnel?
Okay.
This apply to DepEd personnel, sir?
Okay. Yes, there are certain provisions about nepotism, and I don't think that this apply to teaching personnel. This nepotism to the teaching personnel of the Department of Education if my stagnant memory serves me right about nepotism, uh, when it comes to teaching personnel in the Department of Education, nepotism will not apply.
Okay.
But as to non-teaching personnel, nepotism, the law of nepotism will apply.
With regards to a teacher and his school head,
Teacher and
school head,
yeah, I think both are teaching personnel. So I don't think
Yeah.
nepotism will apply.
Okay, thank you.
So
Thank you,
in any
Attorney.
case, what you can do here, example, what you can do if you have, if you can have, what you can do if you have any questions like this for more clarifications, so that you yourself will be able to know the proper answer to your questions on matters like this one that that are legal matters. What you can do is you can try to Google, no, or do your own legal research. Okay,
Okay.
let me show a sample of a legal research. So,
Okay na, Attorney. Thank you. At least naka-refer ka.
I'll just show a little, I'll just show a little, because there is a thorough discussion on that, on nepotism. So, uh, I understand that if ever you can have you have your own other legal matters that you would like to ask, and there is no legal officer to help you, at least I'll be able to teach you a little about legal research. So, like for example, here if you can see my screen, uh, okay, and let's see, you just go to Google and write there nepotism.
Mm.
Okay, for example, this one, let's go to Google. Remember, do not use Wikipedia as source to help you understand a legal problem. Never use Wikipedia. But I'll show here here I'll show you what are the sources that you can use to help you understand about nepotism. So what you can do, you can write nepotism, jurisprudence. Yan, jurisprudence. So always write jurisprudence, because here then you will see cases decided by the Supreme Court about nepotism. So here, once you will see GR number, and then you can see that there's a discussion about nepotism, and this is a very good source for you to click and open and see about what the Supreme Court thinks about nepotism. So here there is an example of a case about nepotism. So you can
Decision.
read, and if ever the case is not similar or cannot be able to help you, so here we can you see the Google,
Yeah.
the
There's a decision of the court.
can you see ruling of the court?
Yeah.
Oh,
Okay.
it is stated here, by way of exemption, the following shall not be covered by the prohibition.
Decision.
Teachers. Oh, so claro, it's clear.
Claro.
Teachers number 2. They are not covered by the law on nepotism. Oh, so this is how you do your, if you have any legal questions on your mind that you would like to be answered, you can do your own legal research. So this is the way you do how you do. This is an example of the way of making legal research, so that you can know the answer even if there is no lawyer or legal officer that you can ask questions. So
Okay,
okay,
thank you, Attorney.
okay.
Thank you.
So, any more questions?
Napamoy questions?
Before any question, remember, please visit and subscribe my YouTube channel. I'll put it again in chat so that later on, this lecture of mine will be recorded. A copy of this recorded lecture will be uploaded in my YouTube channel. So when you visit there, please subscribe my YouTube channel and like it. Okay. So any more questions? No more?
Napamoy questions? Katong speaker? Sige. I would like to request na lang to open your camera so that we can have a photo op with our speaker. Open your camera, please. Da. Please open your camera. And smile. Okay. So wala na may questions? Now is the time kay si attorney, kay si attorney ano nga topic.
Sir Lowy.
Okay na? Sa gingon pa ni attorney, nag-record siya ani. Ang record gud ni attorney may medyo straight kay ako ang recording. Tungod sa unstable ang atong internet connection, medyo putol-putol akong recording. So si attorney ra gyud ang naay straight nga recording which is will be uploaded sa iyahang YouTube channel. So if you have time, kung naamoy gusto nga balikan o tan-aw, wala na sabtan, or kanang to help you answer the assignment nga gihatag sa tong SDS regarding sa kining conduct sa tong webinar. Okay? You can go to the channel ni attorney and review this online seminar. Okay, so last call for questions. Calling once, twice. So I am reading the chat box saying thank you so much, Attorney Lawrence. Thank you for
You're welcome.
for sharing your expertise. Na naliwanagan gid lang tanan gid kay wala na mo say question. Maybe attorney kung after ani ba if they na-realize nila nga napaday sila question jud, can they call you or can
Yes.
they ask the question through me?
Yes, they can ask a question through you so that you can send the question in the Facebook. Or if they will go to my YouTube channel also, they can place a comment there, their questions. They can also write their questions in the YouTube channel or message me in Facebook.
Yes. Yes, thank you so much again, Attorney Lawrence Del Puerto.
Thank you also for the opportunity, and you're welcome.
Yes, thank you, Attorney. Okay, as I said ganiha, naaman to gikuan si Sir Jemro nga